Okay, great. Why don't we get started? Good afternoon, everyone. My name is Kevin Schall, and I am the Speakers Director of the Buckley program. Also online is our Vice President, Hovik Manasyan, who will be moderating this event alongside me. I'm excited to welcome all of you to our Fireland debate on qualified immunity. As politicians ranging from former Tea Party Republican Justin Amash to Democratic Squad member Ayanna Pressley introduce legislative resolutions that abolish the doctrine of qualified immunity, or QI, it is imperative to bring together scholars from different perspectives to discuss the real-world effects of QI, current proposals for reforming the doctrine, and the implications of these policy options for civil liberties in America. We are thrilled to have with us today two guests who have written and spoken on the topic of qualified immunity extensively. Before I introduce them, I want to say a few words about the Buckley program. The William F. Buckley Jr. program is an organization dedicated to promoting intellectual diversity and open political discussion at Yale. We host lectures, dinner seminars, firing line debates, and an annual conference. Our over 350 Buckley Fellows have a wide range of political beliefs, but they all stand united against the formation of a liberal-only echo chamber on campus. By providing Yale students with a forum to engage meaningfully with serious conservative thought, the Buckley program forwards its mission of a more open and more representative political atmosphere, especially at a university where the mission is the cultivation and creation of new knowledge. Buckley Fellows believe that all perspectives, including those of the right, must be heard and examined in good faith. You can learn more about the program and how to become a fellow on our website, buckleyprogram.com. Now, I'll let Hovik introduce our guest.
Thanks, Kevin. Jay Schweiker is a research fellow with the Cato Institute's Project on Criminal Justice. His research and advocacy focuses on accountability for prosecutors and law enforcement, plea bargaining, Sixth Amendment trial rights, and the provision and structuring of indigent defense. Before joining Cato, Schweiker spent 4 years doing civil and criminal litigation at Williams and Conley. He holds a JD from Harvard Law, where he was articles editor for the Harvard Law Review and chaired the Harvard Federalist Society's Student Colloquium program. Following law school, Schweiker clerked for Judge Diana Sykes of the U.S. Court of Appeals of the Seventh Circuit and Judge Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit. He holds a bachelor's in political science and economics from Yale. Christopher J. Walker is the John W. Bricker Professor of Law at The Ohio State University Moritz College of Law and the director of the Moritz Washington, D.C. Summer Program. Professor Walker's research focuses primarily on administrative law, regulation, and law and policy at the agency level. His publications have appeared in the California Law Review, Georgetown Law Journal, Michigan Law Review, Stanford Law Review, and the University of Pennsylvania Law Review, among others. Prior to joining the law faculty in 2012, Professor Walker clerked for Justice Anthony Kennedy of the U.S. Supreme Court and Judge Alex Kaczynski of the U.S. Court of Appeals for the Ninth Circuit. He also worked for several years at the Litigation Boutique in Washington, D.C., as well as on the civil appellate staff at the U.S. Department of Justice, where he represented federal agencies and defended federal regulations in a variety of contexts. During winter semester 2017, he served as an academic fellow on the Senate Judiciary Committee, working on the Gorsuch Supreme Court confirmation, as well as on regulatory reform legislation for Senator Orrin Hatch of Utah. Regarding the format of today's debate, I'll have each of our guests start with a 5 to 10 minute opening statements, after which both speakers will have 5 minutes to respond. I'll then move on to questions from myself and questions from you, our audience, which you can submit through the event using the Q&A feature on the lower panel of the Zoom window. At the end, I will give each guest 2 minutes to offer closing remarks. The event will conclude at 5:30 p.m. With that, please join me in welcoming Jay Schweiker and Christopher Walker virtually to Yale and to the Buckley program. Jay, you can start first.
Great, thank you very much. It's a real pleasure to be able to speak with all of you today on this subject, and especially to be speaking virtually at Yale, where I used to be very active back in the Yale Political Union. So it's nice to be able to do some sort of on-campus debates once again. For the last 3.5 years, the Cato Institute's one of our primary strategic objectives has been the elimination of the doctrine of qualified immunity. And that's because we see this doctrine as one of, or actually as the biggest stumbling block to meaningful accountability in the criminal justice system. So I'd like to start by just giving a brief overview of what exactly qualified immunity is, how we got to the point we are today, why we see this doctrine as so problematic and so undermining of civil rights in this country, and then discuss some possible solutions and how we could achieve those. So qualified immunity is a civil doctrine. It has nothing to do with criminal litigation. It's a doctrine that applies in civil rights suits brought against government officials. And it gives those officials a defense from civil liability, even if they have violated someone's constitutional rights, unless a court determines that they violated clearly established law. And as I'll discuss as we get into this, that is a very difficult standard for plaintiffs to meet. So it often results in the scenario where someone's rights have been violated, but they are unable to get redress for their injuries because they failed to meet that clearly established law standard. So the best place to start to really understand qualified immunity is with our primary federal civil rights statute, which we generally call Section 1983, after its place in the US Code. This is a law that was originally passed in 1871 by the Reconstruction Congress and was intended in large part to give teeth to the recently enacted 14th Amendment, because of course, constitutional rights of freedmen in particular were not being protected after the Civil War. And this statute is very straightforward as federal statutes go. It simply says that any person acting under color of state law, in other words, any state actor who causes the violation of someone's federally protected rights shall be liable to the party injured. So it creates a cause of action in federal court that says if your rights were violated, you get a remedy, period. And for about a century, the courts interpreted that statute to mean basically what it said, that if a state actor caused the violation of your constitutional rights, you could sue them and get an injury. The reasons for that are obviously both to compensate victims of unconstitutional misconduct, but also to provide deterrence against individual state actors to encourage them not to violate people's rights in the first place. But then starting in the 1960s, in a 1967 case called Pearson versus Ray, the Supreme Court started us down the path to creating the doctrine that we now call qualified immunity. The question in that case involved police officers who had been enforcing an anti-loitering law that violated the First Amendment. And a group of protesters who were arrested by these officers brought a civil rights suit against them. And their defense was, well, we didn't think this statute was unconstitutional, so we shouldn't be held civilly liable. Now, what's interesting is that this is actually the exact same posture as a previous case from over 50 years ago, from over 50 years prior, where the Supreme Court handily rejected this argument. And they said, this sort of good faith defense is irrelevant under Section 1983. The only thing that matters is whether you violated someone's rights. But now in this case, in 1967, the Supreme Court effectively switched positions and says, well, because the defense of good faith was a defense under common law, we're going to say that you can raise this defense in these civil rights cases under this particular statute as well. And so they remanded to determine whether these officers really did have a good faith basis for their actions. I think that even that first decision was a mistaken interpretation of Section 1983. But if that's where things had remained, if it had always been an actual good faith standard, I don't think this doctrine would become the problem and the controversy that it has today. And there are a number of other developments that happen over the next couple decades. But the most significant is a 1982 decision called Harlow versus Fitzgerald. And this is really the case that created the modern qualified immunity doctrine. So what the court here said is, actually, this whole subjective good faith aspect is irrelevant. We don't care about that. All that matters is whether the defendant violated clearly established law. The Supreme Court cast this as an objective standard in the sense that it would turn not on the beliefs or intentions of the individual defendant, but solely on whether the state of law was sufficiently clear for a reasonable person to know whether they were violating someone's rights. And the way that that standard has been applied over the last several decades has become increasingly demanding on civil rights plaintiffs. And it's gotten to the point now where it is essentially the case that a plaintiff usually has to find a prior judicial decision in their jurisdiction where someone else's rights were violated in nearly the same way as theirs were. In other words, minor factual distinctions between someone's case and a prior case can be enough for a government defendant to get qualified immunity, even if they have violated someone's constitutional rights. And I'll give just, like I could do nothing but list examples of this, but just to illustrate the sort of thing that we're talking about. In a case called Jessup versus City of Fresno, which came out a couple of years ago, it involved police officers who were alleged to have stolen over $225,000 in cash and rare coins in the course of executing a search warrant. In other words, they were alleged to have abused their authority to enrich themselves at the expense of a particular suspect, and that person brought a civil rights suit against them. But the Ninth Circuit held that, well, we have never addressed this precise factual scenario before, therefore we can't say that the law was clearly established and these officers got qualified immunity. And you see those sorts of decisions again and again and again, where defendants are being excused for egregious misconduct, not because they had a reasonable basis to believe they were acting lawfully, but solely for the reason that the facts of their case did not match the facts of prior cases. Now, the Supreme Court has always insisted that a case on point is not strictly necessary, that you can have sufficiently obvious misconduct, that any reasonable person would have known it was unlawful, even without a case on point. And as we may get into, in the back and forth, there's some evidence that the Supreme Court is trying to reinvigorate that principle a little bit, but it's very hard to make that showing. So where that leaves us is that this doctrine, which was, in my view, essentially invented by the Supreme Court out of whole cloth, it is not based on any textual provision of Section 1983, and it is not, in my view, consistent with the common law defenses that were available in the 19th century, has severely undermined what was meant to be our primary means of holding accountable government officials who violate people's constitutional rights. And that is an especially urgent problem in the context of law enforcement. It is probably not a surprise to any of you listening to this that we have been experiencing for several years now something of a crisis of confidence in our nation's law enforcement officers. And this doctrine has contributed significantly to the public's diminishing respect and trust in the police force. And that has left us in a scenario that is not only results in instances of police misconduct going unaddressed, but has actually made the job of policing itself far more difficult and far more dangerous, because police can't do their jobs effectively when citizens don't have a sufficient level of trust and respect for the people who police their communities. So that is why we think this is such an urgent issue. We probably save a little bit more of the who should be the one fixing this in response to Chris's comments, but it's my view that this is a mistake of the Supreme Court's making, and that it's something the Supreme Court can and should fix simply by reconsidering its very mistaken precedent. There have been a lot of calls for the Supreme Court to do that over the last several years, and unfortunately, the Supreme Court has so far turned all of those down. So the practical matter is this is now mostly something that is on Congress and on state legislatures to address. I think that is, unfortunately, the most likely solution in the relatively near future. But I nevertheless think I continue to believe it's the case that the Supreme Court had an obligation to fix the thing that it broke, and it's a shame that it has so far declined the opportunity to do so. So with that, I turn it over to Chris, and I look forward to the conversation.
Well, this is really fun. I'm going to probably speak past my friend Jay a little bit in my opening remarks, because largely what I have focused on in my writing is more on who should reform it, if it should be reformed at all, but on the who part more. And I think it's important, and I'm hoping that those who decide to tune in for this are interested in law and legal institutions and the like, and we have some aspiring law students and law professors and lawyers in the crowd. And I just want to kind of say at the outset that originally this was a debate about who should reform it. And I think Jay worked on that for many years, and eventually the signals from the Supreme Court were clear enough that we've moved on to asking state and local governments to do reform and to Congress, which in my opinion is the better approach.
Just politely saying that he won that debate.
But I'm going to re-win it here. No, but when I say this, I just want to say, like, I'm not one of those shiny new libertarian, judicial libertarians like Jay. I tend to be an old school judicial conservative that believes in deference to political branches, and small c conservative that believes that change should happen slowly and through a more democratic process. And so when you come to qualified immunity, at least in the context of Section 1983, so this is liability for state officers for violating federal law. My basic answer is the Supreme Court, this is a precedent of the United States Supreme Court that's been around since the 1960s. And as that, stare decisis really should control. Now, I'm a fan of stare decisis generally, and I've heard stare decisis is for suckers, and that's fine. And there's a 6-3 conservative Supreme Court, and maybe I should jump on the bandwagon of, no, but I don't, because I believe as an institution, the Supreme Court really should move slowly and carefully, and that stare decisis is part of our law. But I don't even have to do that here. We don't have to talk about Roe v. Wade or other types of constitutional precedents, because in my opinion, qualified immunity is a statutory interpretation of Section 1983. And because it's a statutory interpretation, the Supreme Court has told us that it gets a super precedent, that the Supreme Court really shouldn't be at all, very seldom involved in overruling a precedent that interprets a federal statute. And why is that? Because Congress can change it. The political branches can change that. And important policy, issues are at stake. And so that's kind of my bottom line. I'll walk through a little bit more on the stare decisis there. And Jay did a great job of doing this. I mean, the qualified immunity has been interpreted as part of the Section 1983 since Pearson v. Ray in 1967. Even the most problematic part of today's current standard, the Harlow v. Fitzgerald, is almost 50 years old, or almost 40 years old, sorry, at this point. It's been repeatedly affirmed by the United States Supreme Court across ideological lines, including Justice Sotomayor all the way over to Justice Thomas. It's even been affirmed on what Will Bode has dubbed the Shadow Docket, which suggests that it's not even that controversial, that it can be done without merits. It's an entrenched doctrine of the Supreme Court, a precedent of the Supreme Court. And I think that's important to kind of recognize where it plays out. Now, that doesn't mean, I don't want to be kind of put into the corner that the Supreme Court should never overrule statutory precedent. When things change or when it's not administrable, there are exceptions to that. Or if it's just really, 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 really wrong as an original matter, that might also be an exception. But I just don't see that here. As an original matter, we can dive into it more. I agree with Jay that the current version you don't find in the 1800s as the backdrop against which Congress legislated, but you find immunities all over the place in the 1800s, even immunities for executive officers. So it's not. I'm not convinced by what the legal case that scholars have made as an original matter against it. And it's administrable. And Jay will tell me it's not administrable, but it is. Courts, administer it day by day in ways that are quite clear. Now, sometimes it's administrable too strongly, and I agree with Jay on that, and maybe that's where the Supreme Court's going to push back. The last thing I want to say on the stare decisis point is there are deep reliance interests at stake here. State and local governments indemnify their officers now. As Jay mentioned, the statute itself suggests that officers should pay for this out of their own pockets. It's personal liability, not official liability. But in practice, state and local governments indemnify about 99% of the time. Joanna Schwartz did a great study a few years back of some of the larger police departments, and she found that that over a 4-year period, police departments paid over $700 million to settle almost nearly 10,000 lawsuits. And so you can imagine without qualified immunity, what that would do. Aaron Nielsen and I have a paper that just came out in the Georgetown Law Journal last year. We document just the breadth and diversity of approaches states have had for indemnification, and just kind of underscores those reliance interests. Now, does that mean that we shouldn't get rid of it as a policy matter? No, I'm not saying that. What I'm saying is that if we are going to get rid of it, because there is so much reliance interest and there's a policy call to be made, this really is something more that should be addressed to Congress instead of the courts. So I'm happy to jump more into the policy stuff later. I have a feeling I'll do that on my rebuttal, but I'll just kind of stop there. It's not a popular policy argument to kind of come to Yale virtually and argue that, courts should act slowly and defer to political branches. But that's the type of conservative I am, and we need more of us, judicial conservatives, kind of the more Burkean, slow-moving, respecting tradition, history, and process, and leaving to the political branches to make those big policy decisions that will really, in my mind, upend the status quo in the states and the local government. So I'll stop there.
Yeah, and just to, I mean, briefly respond to that. I mean, I think, look, just as something to acknowledge up front, like the Supreme Court at this point is almost certainly not going to reconsider qualified immunity. And I still think this is an interesting question, and I like the sort of institutional kind of legal theory debate, and I assume that a lot of people here do as well. So I'm happy to have that discussion. You know, realistically, the action is going to be in the legislature in the near future, and that is where I think advocates should be focusing most of their work. Nevertheless, to respond to a few of these points, though, I think that, you know, the sort of respect for stare decisis that Chris is talking about, at least in the context of qualified immunity, strikes me very much as stare decisis starting right now. Because the Supreme Court for over a century has completely disregarded stare decisis in its interpretation of Section 1983. So the first major Section 1983 decision is a case called Myers versus Anderson in the very early 20th century. This is the one that I was referencing that was similar to Pearson versus Ray. And this case involved election officers who had refused to register Black voters under a grandfather clause statute. And their defense was, well, you know, look, we weren't acting with malice. We thought this was allowed, so we shouldn't be held personally liable. The Supreme Court said, no, that's irrelevant. You violated their rights under the 15th Amendment. This statute says you're liable. That's it. And then 50 years later, you know, one might have thought that that would be a relevant precedent for the court to consider when essentially the same question was brought up again in Pearson versus Ray. And the Supreme Court didn't even acknowledge that it was reversing its position on this essential point of civil rights law in this country. Pearson versus Ray itself seemed to suggest that this good faith defense was based on the fact that certain limited common law torts had good faith as an element. So for instance, that because that case involved unlawful arrests, the court said, well, the tort of unlawful arrest allows as a defense good faith and probable cause. So because this particular civil rights suit is analogous to that tort, we will allow it. But very quickly, the Supreme Court disregarded any reliance on analogous common law torts. In Harlow versus Fitzgerald, the Supreme Court entirely recharacterized the sort of defense that qualified immunity was. And like I said in my opening statements, if we were still in an actual good faith regime, I don't think this would be a controversy today. So, and if you look at, in terms of like deference to the political branches, I agree in the sense that I think when Congress passes a statute, the Supreme Court should interpret that statute as Congress wrote it and not import their own policy preference, which is exactly what the court did when it invented qualified immunity, or the modern qualified immunity, in Harlow versus Fitzgerald. The Supreme Court wasn't even pretending to interpret Section 1983 then. That case was not even a Section 1983 case. It was actually a case under the Bivens Doctrine, which applied to federal officials. And then in a footnote, the court says, oh yeah, and by the way, we'll apply the same thing to Section 1983. So the court that invented qualified immunity obviously was not showing any respect for the political branches. And then, the other thing I'll add is that in 2001, in a case called Saucier versus Katz, the Supreme Court announced this rule that lower courts, when they grant qualified immunity, they have to first decide whether or not someone's rights were violated, and then they can decide qualified immunity. That decision proved very unpopular with lower courts because they preferred to be able to just dismiss a case based on a lack of clearly established law without having to resolve difficult constitutional questions. So 8 years later, in a case called Pearson versus Callahan, the Supreme Court reversed that precedent from just 8 years ago. And that case was a discussion about why stare decisis should not preclude reconsideration of the qualified immunity doctrine. So, I guess I think it's, in some sense, it's kind of rich that like now for the first time ever, that there is a, serious legal historical argument against this doctrine. Now, stare decisis is relevant when it hasn't been relevant for a century. And then I just finally, I would add, I don't think that, I agree with Chris that stare decisis is heightened in the legislative context. I think if the Supreme Court has issued an interpretation, an unambiguous interpretation of a statute that there's no dispute over, there's a very strong argument against reconsidering it for predictability and reliance-based reasons, like you mentioned. I agree with that principle, but I don't think qualified immunity is predictable or administrable because the clearly established law standard is inherently amorphous. There is no principled way to say how similar do the facts of prior cases have to be to the current case before you can say that the law was clearly established? And lower courts have been, the Supreme Court has had to aggressively reverse lower courts over the last several decades that have been basically too willing to deny immunity. In other words, the Supreme Court is ratcheting up the stringency of the clearly established law standard, but it can only do that through reversing lower courts who they think get it wrong. There's no, like, if you look at the Supreme Court's, like, the black letter law description of the clearly established law standard, it hasn't changed really for like 50 years, but the way it is applied in lower courts has changed. So I think what that speaks to is the fact that this enterprise of trying to say, well, you violated someone's rights, but the law wasn't sufficiently clear, is just not a workable, predictable enterprise. And the court would be better off returning to what Section 1983 actually says.
So Jay packed a lot in there, so I'm not going to cover everything in response. So if you find something persuasive I don't cover, ask a question and flag it. But I do want to respond a little bit. One, I'm glad that he didn't go with kind of the lazy argument that Section 1983 doesn't include any defenses, doesn't say anything about defenses, so we shouldn't, they're not there, we shouldn't interpret a statute to add them, because it's a really lazy argument. And Jay doesn't make it, right? We always read statutes against the backdrop of common law, especially statutes that were passed in the 1800s. We assume that Congress passes statutes against the backdrop of common law. So it's a criminal statute where you assume a mens rea requirement or an insanity or other defenses, right? Even though they're not in the statute. And similarly, when it comes to Section 1983, the court has to figure out what common law defenses existed at the time that the statute was enacted. And I haven't seen any real serious disagreement that judicial immunities and legislative immunities existed. The real debate is about executive immunities, right? And there, I think the history is really murky. I think Jay and Will probably have a little bit better of an argument than some of those who argue that they did exist, at least in the robust form we have now. I definitely agree with Jay on that. But that's so I think that's important to kind of work through. So the fact that the Supreme Court identified a defense in 1967 as part of the statutory framework, that in my mind, that's kind of where that is. Now, the shifting doctrine point, Pearson was a case that decided the year I was clerking for Justice Kennedy. It doesn't have anything to do with the substance of qualified immunity. It's entirely about procedure, about court procedure. I don't even view that as substantive stare decisis. It wasn't interpreting the statute. It was just explaining how courts should process claims under Section 1983 as a procedural matter. I do think Jay's right, though, that it has been ratcheted up as a substantive matter since 1967. And I'm not sure what to do with that. It hasn't been reversed, but as the court has tried to apply it and kind of flesh out what it means and make it more administrable, they have made it harder for plaintiffs to win. I don't agree with Jay, strangely, that the battle at the Supreme Court is completely done. And I would just flag an article written by former Texas Solicitor General Scott Keller that was published in the Stanford Law Review earlier this year that actually attacks, in my mind, Harlow v. Fitzgerald head on as an original matter. And I do think that if you're going to kind of tinker with qualified immunity under statutory stare decisis, the more vulnerable part of qualified immunity is Harlow and not the kind of the original formulation. And that would basically kind of put in, more understandable terms, would reestablish what's more consistent with a good faith standard, that an officer has to act in good faith on those lines. And then the last thing I just kind of briefly talk about, and this is getting back to Jay's introductory remarks, is why would we have a common law immunity like qualified immunity in the 1900s, or in the 1800s? Why is this a backdrop principle? And there are kind of four basic principles. And I want to just get this out now because I think we'll have a policy debate over the next half hour. When the court explained why they were recognizing qualified immunity in Harlow, they give us an idea of what they're trying to avoid. And there are kind of four different approaches. One, they're trying to avoid officers from paying litigation expenses, right? So it's not just an immunity from damages, it's an immunity from suit. It's at least theoretically decided at the motion to dismiss stage, not after discovery, or definitely not after trial. And they're also trying to avoid opportunity costs. They don't want litigants to be able to tie up government officials in court as opposed to doing their job on the streets or in their offices, right? They want to kind of subvert the democratic process of we elected these people to implement the law. We want them to implement the law and not be kind of tied up in litigation. And both of those kind of tie in with the third point, which is that they want to encourage people to enter public service. And if individuals are worried about being sued or being tied up in litigation or having their names on, as defendants in civil suits for constitutional violations, it's going to be a lot harder to hire and retain the best people for public servants. And so there's kind of three reasons. I have my issues with those reasons, but I'm just throwing them out there. But the fourth reason I think is really important. It's not to over-deter. In other words, they were worried about chilling officers from making tough decisions in their jobs that may affect people in different ways, right? Whether that's in like a law enforcement context where you're trying to protect other people from the harms of someone that you're encountering, or whether that's in like the teacher context where a teacher might suspect that a child is being molested at home and trying to figure out whether they should report them and how they should report them, whether they should investigate it further. So officers, government officials make tough decisions all the time. The law is structured in such a way to discourage action. And I think qualified immunity is a way to kind of encourage officers to make decisions in an instant of uncertainty, make a hard decision in order to do their duty, which oftentimes is to the benefit of someone else, protecting someone else's rights. So I think that's a tricky one. Now, of course, and I'll end here, in the police context, I've got my feelings as a policy matter, as a more libertarian policy person, although judicially conservative, right? But one thing you have to realize is Section 1983 doesn't just apply to law enforcement. It applies to social workers. It applies to any state or local government official acting under color of state law. And that's one reason why Congress is a better place to address this, because Congress can actually eliminate it for some officers or some actions and not for others.
Chris, I think you put your finger on it when you said we might be having a policy discussion, because that's what I wanted to segue us into. Jay talked about how the Supreme Court was unlikely to approach this issue in the coming years. And I wanted to ask you both about what sort of policy alternatives that you would like to see at the state and federal level. Chris, I wanted to start with you. I know you talked about the problem of over-deterrence. And I was curious because you mentioned teachers, school administrators, public school administrators are also insulated under the current QI doctrine. Would you support a policy that cut back on immunity insulation for administrators who are not making those line of fire judgments, but rather prevent while still protecting police officers who are in the line of duty?
Yeah, it's interesting. I don't actually have strong policy, positions on this. I probably would actually lean the other way. And I'm not surprised that when the Dems in the House put forward their Justice and Policing Act, that they did too, right? There was all they eliminated qualified immunity for was law enforcement. They didn't touch police officers or anything else. And I think that's just something that resonates with me, at least in the excessive force context, in the sense that, and maybe this is just my libertarian bones here, but like my worst nightmare is getting pulled over on a dark street by law enforcement and not having any control over what happens to me after that, right? And qualified immunity kind of encourage officers to err on the side of what they want to do. Liability encourages officers to err on the side of not doing something to harm me, right? And I'm not the person who usually gets pulled over, as we've learned, right? And so I'm even more concerned about those who regularly get pulled over because of race or gender or anything else, right? And so that's what keeps me up at night as a policy matter. I'm less concerned about a teacher doing something. I mean, one thing that's important to mind is qualified immunity only protects for monetary damages. Like if a teacher is like repeatedly suppressing someone's speech rights or trying to shut down a rally, or we can still run to court and get injunctive relief to stop that teacher from doing that in the future. With excessive force claims, there's no injunctive relief, right? I mean, once excessive force is exercised, that's the ball game. So I think if we're going to reform qualified immunity, I agree with the Democrats in the House, which I don't say very often, that it really should be, focused more narrowly. In fact, I'd go maybe a step further, and I have like in a blog post where I've kind of identified different, approaches, and you might just want to limit the Fourth Amendment, or you might just want to limit excessive force. Or I know some Republicans have said maybe we should only limit it to excessive force claims that led to a wrongful death, similar to kind of like a felony murder type rule for civil liability. So, I mean, I think those are the types of questions that really should be debated in the halls of Congress and in state legislatures. I know, Jay, I'll stop there. I'm speaking too long.
Jay, I'd love if you respond to that, whether you agree or not. And also some of the proposals that you've seen. I know you and the Cato Institute have led this charge to reform it at the policy level. So I'd love to hear about your experience with that.
Sure. I mean, I think the bottom line is that the doctrine needs to be eliminated entirely. I think it is a basic axiom of our legal system that, for every right, there is a remedy. And that is the principle that was given life in Section 1983, which explicitly said every person acting under color of state law, not just one particular sort of executive officer, any person acting under color of state law.
Whoa, time out. So judges should have no immunity either. Is that what you're saying? And legislators as well?
I agree with you that those immunities were part of the background of the common law background. I also think that, this is maybe a little bit more detailed than we need to get into, but the way that judges and legislatures act aren't really the sorts of actions that give rise to distinct constitutional violations in the way that we normally conceptualize constitutional injuries in our system. We normally wouldn't say if a judge interprets a statute incorrectly, they've violated your rights. You might disagree with their decision. So I actually don't think that circumstance even comes up that often in the legislative or judicial context. But in the executive context, that is the judgment that was made in Section 1883. And I think that is, that should be our baseline, that when someone's rights are violated, they get a remedy. Now, a couple of points about the sort of over-deterrence. One, it's very important to understand in the policing context that you don't get to sue a police officer because you don't like the decision that they made, or even that you think they made the wrong call. Most cases against police officers arise under the Fourth Amendment. And the Fourth Amendment itself incorporates a reasonableness standard that is very deferential to on-the-spot police decision-making. The Supreme Court, when it is interpreted, just the Fourth Amendment itself, deciding what counts as a violation of your Fourth Amendment rights, has made very clear that police officers do have to make difficult split-second decisions under conditions of danger and uncertainty. And it's not fair or appropriate to, with the benefit of perfect hindsight, second-guess all of those decisions. So the fact that an officer uses force that turns out to have been unnecessary does not mean that they violated anyone's constitutional rights, so long as they were acting reasonably under the circumstances known to them at the time. So I think that it's very understandable that people who feel protective of police officers and of the difficult job they do say, hey, how is it fair to sue them anytime they make the wrong call? But that has nothing to do with qualified immunity. That protection is built into our constitutional law. Qualified immunity is in some sense a kind of double counting of that difference. I think that on the point about whether there's over deterrence or difficult calls, I think the right policy solution there is not to deny compensation to a victim whose rights were violated, but to place the financial responsibility on the public employer of the individual rather than solely on that individual. We strongly favor a shared liability regime between public employers who employ people who violate people's constitutional rights and the individual actors who violate people's constitutional rights. As Chris mentioned, realistically, most of the time, at least in the policing context, but this is certainly true elsewhere, it's employers who end up paying anyway. It is very rarely the individual officers who foot much, if anything, of the bill. So I think that to the extent that we're concerned about, oh, well, what about this poor teacher who didn't understand the Fourth Amendment enough? If that's really the case, if there really was a close call on that point, but someone's rights were violated, I would say that victim should get a remedy. But perhaps it's the school that should be liable rather than the individual teacher. Or you could sort of apportion liability, at various degrees. This is the approach that Colorado took in its state level civil rights reform. They basically created a state system where any police officer who violates someone's rights is fully liable. There's no qualified immunity, but they are guaranteed indemnification by their employer unless they weren't acting on a good faith basic belief that their conduct was lawful, in which case the officer has to contribute $25,000 or 5% of the judgment, whichever is less. So in other words, it recognizes the reality that the employer is usually going to be the one with the deep enough pockets to pay a judgment, but it still gives the individual actor skin in the game. And I think that's really important. Even if individual government agents aren't going to be the ones paying the bulk of the judgment, there's a big difference between some skin in the game and no skin in the game. And I agree that these kind of fine lines are obviously not something the Supreme Court can or should do. I mean, now we're talking entirely legislatively. So, you know, I don't necessarily think there's like one true approach here. I mean, I would have preferred Congress to eliminate qualified immunity entirely. I understand why they decided to start with and focus on the law enforcement context. I think that is where the problem is most urgent. You know, but I just start with the basic principle that if someone's constitutional rights are violated by an agent of the state, they deserve a complete remedy, period. And that requires getting rid of qualified immunity.
I just want to remind our audience that they can ask questions using the Q&A feature at the bottom side of the screen. My question is, both of you seem to be, you know, somewhat in agreement that something needs to be done, but what's the likelihood that something will be done at the federal legislative level, especially on the Republican side?
It's not going to happen in this Congress. I mean, you know, in the Senate, the key negotiators in the Senate, which have basically been Tim Scott and Cory Booker, have been kind of wrestling with this issue over the summer, and there were a lot of back and forth suggestions of possible compromises that were on the table, but just, you know, a few weeks ago, they basically officially announced that those talks are dead. So there's not going to be policing reform in this Congress. Unfortunately, you know, it's funny because before this became a matter of national politics, this was a much less partisan issue, right? You know, Cato organized amicus briefs before the Supreme Court that other federal judges have called the most diverse array of amici ever assembled. So this included groups on the left, like the ACLU and the NAACP, libertarian groups like Cato and Reason and IJ, but also very conservative groups like the Alliance Defending Freedom, which is very, you know, such a conservative religious liberties group that, you know, some very silly organizations call them a hate group, right? I mean, you know, the Second Amendment Foundation. So, you know, groups that maybe have never agreed on anything else before, but all agree that this doctrine is undermining the enforcement of constitutional rights. And I think what's unfortunate is that the law enforcement lobby is incredibly powerful. It's incredibly powerful at local and state levels and at the federal level. And, you know, for whatever reason, they have outsized influence on a lot of Republican offices. And, you know, they successfully spread a lot of misinformation about qualified immunity that I think made it something that Republicans felt like they couldn't touch, at least in this legislative cycle. So I think the real action is at the state level at this point. States obviously cannot change federal law, so they can't get rid of qualified immunity as a federal defense, but they can do what Colorado did, as well as New Mexico and New York City, which is to create state level civil rights laws that are basically analogous to our federal civil rights law, and then clarify that qualified immunity will not apply to those state civil rights suits. So, you know, we're working in a lot of other states right now that we expect to take this up in 2022. My hope is that once we see more successes at the state level, it'll build momentum and also, frankly, undercut a lot of the hyperbolic predictions of disaster that opponents of QI reform have lodged. The idea that if you got rid of this, you just wouldn't have a police force. Well, you know, there are still police in Colorado. And I think we're gonna get more and more empirical evidence about the effects and the non-effects of qualified immunity reform, which hopefully means we can bring it back to Congress in a few years. But, you know, right now, it's not getting through this Congress.
One of our audience members asked this question. He says that he's reading Corbett versus Wickers on the American Bar Association website, where the district judge denied QI to a policeman, but the decision was reversed by the appellate circuit on the grounds that there was no prior judicial decision involved in the unique facts of this case. His question is, how do judges have a precedent to rely on unless they let the district judge's ruling stand? Chris, do you want to take this since Jay took the last one, or?
Sure. District judge rulings aren't precedential anyways, and so you need a circuit court ruling to establish the precedent. And this is one of the issues, and Jay kind of hinted this before with Saucier and Pearson, Pearson v. Callahan. For a while, the Supreme Court required lower courts to reach constitutional questions. If you think about qualified immunity, there are two questions, right? Did they violate the Constitution? And was the right that was violated clearly established at the time of the action? And for a while, the Supreme Court said you have to decide whether they violated the Constitution, even if it's not clearly established. And the year I was clerking for Justice Kennedy and Pearson v. Callahan, they got rid of that. And they said, no, actually, in an opinion by Justice Alito, which is kind of funny, he gave like 4 or 5 reasons why they should reach it and like 15 or 16 reasons why they should never reach the constitutional question. Of course, any of those you could actually flip around and just put not in front, right? But he really loaded, I think, the deck to encourage lower courts not to reach constitutional questions. Aaron Nilsson and I have written about this pretty extensively. It's a problem. I mean, I agree that courts shouldn't always reach constitutional questions, but the law doesn't develop if they never reach them, right? And we call that constitutional stagnation. So in a couple of articles we published a few years back, we argued that the Supreme Court should require lower courts to at least provide reasons for why they're not reaching constitutional questions, to try to kind of encourage more thoughtful, deliberation. Because it's really easy for a judge to be like, I don't want to spend the time to figure out this hard constitutional question, so I'm just gonna say it's not clearly established. And again, sometimes that's right. I mean, there's some really poor lawyering. A lot of this time is just on the pleaded allegations. There are no facts yet, right? And so there are times when they shouldn't reach it, but it is a problem, especially in cases where you can't get that right established in other contexts, like excessive force, like where you can't, sue for injunctive relief, or you can't sue a city under a municipal liability theory. So, well, that's not his question. I did want to kind of flag that, but that is one of the issues in the background. Now, if you're judicially conservative, you might kind of wonder, can they even reach constitutional questions if it's not clearly established? Like, is this just an advisory decision? Should we really be trying to make constitutional law in cases where it doesn't make a difference? And I think the answer is yes, they should. But if you have that instinct listening to this, you're not alone. Justice Kennedy at one point, even in a separate opinion in a case, kind of was like, why are we even doing this? There's no clearly established law. This won't help this plaintiff. How do we have even authority to kind of issue these constitutional rulings in cases where it doesn't affect the outcome? So
I would just briefly, I agree with all of that pretty much. Just to give an example of how degenerate this has become in the lower courts. There's a case just earlier this year called Frazier versus Evans, which involves the First Amendment right to record police in public. Now, this is not an issue that the Supreme Court has explicitly addressed, but 6 different circuit courts have held that there is indeed a First Amendment right to record police in the course of their public duties. No court has found to the contrary. And in this particular case, Frazier versus Evans, Denver police officers threatened to arrest and illegally searched a man, all because he was recording them in public. Now, these officers had been explicitly trained that citizens do have this First Amendment right. So they had actual knowledge that they were violating his rights. But the appellate court nevertheless granted them qualified immunity because the 10th Circuit, unlike the 6 other circuits that had already addressed this question, had yet to address it. Moreover, the officers in that case stipulated that there is such a constitutional right precisely because they wanted to avoid making it a disputed issue so that the court would avoid deciding the constitutional question. And that's exactly what the court did. So even though these officers have been trained for years that this right exists, and every other court that has addressed it is held as such, they got immunity, and they could go commit the exact same misconduct tomorrow and get qualified immunity again. That is how absurd this catch-22 of qualified immunity doctrine has become in the lower courts today.
Chris, earlier you talked about the indemnification mechanisms that are present in, you said 90% of jurisdictions around the country. And I wanted to ask you if you could elaborate on that. What does that mean for Jay's point about having skin in the game? Does that help or hurt the case for abolishing qualified immunity? And what would you do to sort of reform in this area?
Well, I mean, in my position, from a judicial reform of qualified immunity, it hurts it a lot because state and local governments have legislated and contracted against a backdrop of qualified immunity, which is a reliance interest under the stare decisis kind of standard. When it comes to the policy argument, it changes the game. Joanna Schwartz is completely right, which is written on indemnification, that the original reason for qualified immunity was to prevent officers from losing their homes, right? Or like losing their livelihood, right? And nowadays, when they're almost always indemnified, that's not a concern. The officer's concerns now are more, I'm going to be tied up in litigation, I'm going to be deposed, I might have a jury trial where I'm the face of the wrongdoing or whatever, right? And I still think those are serious interests the officers have, but it's not the same as worrying about whether you're going to lose your home, right? So at the policy level, that changes the debate. On the flip side, though, our state and local governments haven't been doing very well the last few years, financially. And there's a big open question of how much will qualified immunity, its elimination, affect state budgets and local budgets, right? And I think that's a serious question. I'm a law professor. I don't get into policy. Maybe Jay has more on that, but I think that's kind of the worry now. And I think that's why people in Congress, even Democrats, are very worried about eliminating it entirely, because they've got to go and represent their states and their local governments and explain why there's going to be an increased cost on the budget front.
Yeah, the cost point is interesting. I've been a part of a lot of debates at like the state and local level around this. And, a lot of the supporters of QI reform are very quick to sort of stress, it's not going to have a major cost impact. So, don't worry about that. And I'm a little bit more hesitant to say that. I mean, partially because that's not my area of institutional expertise, but also because I think it would be surprising if it didn't have some noticeable financial impact, at least in the short term, because if that weren't the case, then, it would mean that there was really no need for qualified immunity reform at all, right? It's like one of two things is true, right? Either you can either say, things are basically fine, officers respect people's rights, this isn't a huge issue, so there's no need for it. Or you can say this is going to have a major financial impact. But you can't say both at the same time. Because if there is a major financial impact, what that means, almost by definition, is that there are currently many unaddressed rights violations occurring. So I think what's important to keep in mind is that civil rights laws are supposed to have not just a compensatory effect, but a deterrent effect. So this is a dynamic question. It might well be the case that there's a significant financial impact in the short term, which is therefore going to be something that causes, municipalities, public employers, states or whatever, to revise their hiring, training, and retention policies to cut down on the number of constitutional violations. That deterrent effect of the financial impact is a feature, not a bug of civil rights laws. So when people say, and I understand this is not what Chris is saying, but when people say, this is going to be too expensive, we can't pass this, what they are basically saying is we cannot afford to protect the constitutional rights of our citizens. And if that's really true, what that indicates is that there is a massive underlying problem that needs to be addressed.
Yeah, I want to just kind of follow up one, because there's been a recurring theme on Jay's side in the last few comments on, that for every constitutional right, there's a constitutional remedy. And spoiler alert, when you get to law school, that's not actually true. Historically, constitutional rights often don't have constitutional remedies. We've had sovereign immunity for a long time where you can't sue the king. It came from England. Shocker, the reason why we're suing under Section 1983 individual and personal capacity is because the Supreme Court, I think, rightly has read it as not affecting state sovereign immunity. You can't sue the state official, for monetary damages unless the state consents, right? And so while it's a good fundraising campaign to say, this is that. And one of the main reasons for that is that ultimately we do pay for that, right? That someone pays for that, and we do, the taxpayers, we the people. And so we need to consent to that type of thing. I agree with Jay in a lot of circumstances we should. For egregious constitutional violations, there should be a remedy. But what qualified immunity, at least it was originally understood, was a good faith defense. It was when an officer was acting in good faith, thought they were following the Constitution, and it turns out after the fact that they weren't, right? It's when they're, and these are other examples, when they're actually following state law that a court had said was constitutional, and the Supreme Court later said it wasn't constitutional. So different examples, but it's not just about the hard decisions where they make the wrong constitutional decision. Qualified immunity is about decisions where they think they are making the right decision, and courts and legislators and others have told them that's the right approach. And I think that's really important because there is an over-deterrence issue there. And I can't quantify it, and I haven't even tried it. It's not my area of expertise. But if you have a world where officers are afraid of being sued and know that even if they were doing it in good faith and following all the training they have, but they'll still be held monetary, liable, they won't act, right? And I think that's a worry. Now, is it an overblown worry by police unions? Absolutely. I'm not going to disagree with Jay on that. But I think it is still a legitimate worry that you have to kind of work through as a policy matter if you're debating this in the halls of Congress or state legislature.
That makes sense. I wanted to ask one last question of you both, which is just what does the future look like to both of you? I know, Jay, you mentioned earlier that this Congress probably doesn't have the appetite to pick up abolishing qualified immunity legislation, but do you think that the states will adopt this en masse? Why haven't we seen them do so already? And what is your future prognosis on this issue for both of you?
Yeah, I think, part of the reason that we haven't seen states handle this is because federal law purports to handle it, right? We purport to have a uniform federal solution to this issue. And I think, just a slightly more fundamental point, right? Like I, work at the Cato Institute. I'm very in favor of federalism, right? Both as a sort of constitutional and also just sort of political philosophical matter. But if there's one thing that even very hardcore federalists, I think, agree that the federal government can and should do and is authorized to do, if it, maybe second after national defense, is protecting the constitutional rights of its citizens. And, not to oversimplify, but like the lesson of the Civil War and Reconstruction is that state governments cannot always be counted on to protect the constitutional rights of their citizens. That's why Congress passed a federal law that was meant to provide a uniform federal solution to this problem, so that whether or not your rights were protected did not depend on the whims of your particular local government. Now, somewhat ironically, we're now in a position where there are lots of state governments who are want to go much further than Congress will to protect constitutional rights. And so what I think the future looks like I mentioned earlier, is more action at the state and local level, cities and states creating civil rights laws that preclude the application of qualified immunity. And what I think that will lead to is it will illustrate the awkwardness of this patchwork protection of constitutional rights. Because you're going to, I hate to say this, but like, we're going to have another George Floyd, right? We're not going to suddenly stop having high-profile instances of police misconduct that seem inexplicable to people watching and generate massive public outrage. And what you're going to start seeing is, well, in this state, that person is left out in the cold, but if it had happened next door, they could have had a remedy because their state has a civil rights law that doesn't allow for qualified immunity. And so, my hope is that discomfort pushes Congress to sort of come back to this issue and take seriously the original purpose of Section 1983, which is to create uniform protection for constitutional rights for everyone across the entire country.
Just real quickly, because I know we're at 5:30. I think the Supreme Court will continue to chip away a little bit and make it easier for plaintiffs to win by saying you don't have to have a case identical. They did that last term. I think you'll see that continue to kind of be a somewhat regular return. I think there's a really good chance in a new Congress that you'll see it restored to a good faith defense that will get rid of Harlow and Fitzgerald. I think Scott Keller's article from the Texas Solicitor General, conservative, constitutional conservative type, provides a lot of cover for Republicans to carve back on it a bit. And I agree with Jay, at the state and local level, I think you're going to see some state and localities do a lot and others not do a lot. And some of that might be good. I don't know if the same principle should apply in rural America as it does in urban. I don't know, right? And some of it's going to be bad, as federalism often teaches us, right? So I think those are the kind of points. I guess I'd end, though, where I probably disagree most with Jay, and I'm not a police reform expert or anything. I don't think qualified immunity is a solution to our broken criminal justice system, getting rid of it or not. I think when it comes to police, there's got to be much more systemic reform of police unions, of the hiring and firing and management of police officers. There's so much issues I think are so much more important to actual reform on the ground. I'm not saying qualified immunity is not important, it is, but there are other issues I think that we really should address more of our attention to, both as scholars, but also as policy folks trying to figure out how to fix.
And let me just, I agree with Chris. Qualified immunity is not a silver bullet. I don't think it is the one, this one weird trick will, fix policing in this country. I think it is an essential first step, because I think we're at a point where, because the problem is not just that we are inadequately deterring police from violating people's rights. It's that the public sees accurately that police are rarely held accountable. And that undermines public trust and respect for law enforcement, which in turn makes the job of policing more difficult. And so I think it perpetuates this vicious cycle of people trusting the police less, and therefore making police sort of more agitated and making it more likely to have, hostile encounters between citizens and the police. So everything that Chris mentioned that is I think also very important, and we shouldn't kid ourselves that this one thing will fix our problem, but I do see it as an essential first step toward fixing that problem.
Seeing that it's already 5:33, I want to thank Mr. Schweiker and Mr. Walker for a wonderful debate. Yeah, thank you. Thank you so much. And thank you for all of our audience members who came.